Hello there. I hope you're doing great. My name is Mutiaba Conrad, and today I'll be basically taking you through contract law and specifically the topic of consideration. But before we start off, please do not forget to subscribe to my channel so that you're always able to get an update of the required topics for your own coverage. So basically, today we are going to be looking at consideration under contract law, but with specific interest on a certain question that I wanted to take you through. And specifically, the question states that the decision of the Court of Appeal of England and Wales in William versus Rafi Brothers and Nichols Contractors Limited significantly eroded the rule in Stilk versus Myrick. Further, the reasoning employed by the court devalued the requirement of consideration, close quotations. So the task for that question is, one, to discuss the veracity of the statement, and then secondly, to give your opinion as whether you agree with the decision in William versus Rafi Brothers, and then lastly, you give reasons for your answer. So that is the question we are going to be focusing on today, and I'll be discussing for you in material detail what you're required to do when you are approaching that question. But as you will quickly realize, you cannot be able to excel or perform well and understand how best to answer this question unless a student has properly understood the topic of consideration. So the whole question, point number one, is that it's about consideration. And unless you have understood the topic of consideration under contract law, you will not be able to sufficiently understand and answer and make a proper analysis on that question. Eventually, you will end up getting minimum marks. So step number one, you have to understand the topic of consideration. After understanding it, I will then take you through the approach and what you're required to do and some of the areas you're required to look at and the sections and the analysis that you're required to make. So the modus operandi in our discussion today, first, I'm going to take you through the topic of consideration, and after taking you through that topic, then we will look at the approach to that question. We discuss what you're required to do, what you should include in your essay, the laws you should look at, the cases, the analysis you should make, how you should conclude, and how you will be able to write a good paper when you're answering that question. So basically, that is how we are going to proceed in today's discussion. So the topic we are looking at is consideration. After looking at it in detail and after you understand the topic, then we are going to look at the approach to that question in material detail. Now, consideration. Consideration, as you may have realized from my previous classes, we went through offer, we went through acceptance, and now we are reaching a time where we have to look at consideration. So first, under consideration, this is what we're going to look at. One, we are going to define consideration. We are going to talk about the types of consideration. We will talk about the exceptions. We'll talk about the general rule governing consideration. We'll also talk about the exceptions to that general rule. Then we are also going to look at the basic rules governing consideration. We will also look at the exceptions to the rule that consideration must not be passed. Then we are also going to focus on the considerations and the performance of existing duties, and this is where that question is actually surrounding. Then after that, we will look at the exceptions thereunder. So basically, that's what we are going to discuss, and after doing that, then we'll go through the question that I stated for you from the onset. So first, what is consideration? First of all, you need to know that consideration is defined under the law. Look at section 2 of the Contracts Act 2010. It defines consideration as a right, interest, profit or benefit, or forbearance, detriment, loss or responsibility. So section 2 of the Contracts Act defines consideration. Together with the case of Curie versus Missy, 1875, volume 1, APP CAS page 554. Those two authorities define what consideration is, and section 2. But a more simpler consideration, how to really understand consideration is, the simple definition can be that consideration is the price of which a promise is bought. Okay, very simple definition. Or the second simple definition that you can also use is, and this is according to Professor Traitel in his book Law of Contract, he defines consideration as giving something of value. That the moment you give something of value to another person during a transaction, that is consideration. That's simple. So choose any of the three definitions, it is as good as gold. So consideration, basically in summary, it is the price you pay. Okay, it is the price you pay for a promise that you have bought. Okay, or when you give something of value to someone during a transaction, that is consideration. So consideration can be anything. It can be money, it can be land, it can be anything. Okay, so basically that's it on the definition of consideration. Let's now quickly run and we'll look at the types of consideration. Okay, types of consideration. Now I am going to send you to go and look at a very interesting case that discusses all the principles of past consideration. Okay, it's a Ugandan case. You can find it online. Just go on Yuli on your phone or your laptop and put the case of Lanyero versus Okene and another. Lanyero is L-A-N-Y-E-R-O versus Okene. Okene is O-K-E-N-E and another. It's Civil Appeal number 29 of 2018. It discusses principles of past consideration. This is judgment of Stephen Mubiru. Now it's very rare in this country to find cases or jurisprudence on past consideration, but Stephen Mubiru hit it again. Justice Stephen Mubiru makes a very good discussion on past consideration. Please ensure and make sure you go and read that case. Very interesting. It will increase on your understanding of consideration. So let's proceed with that case at the back of our mind. Let's now proceed to look at the types of consideration, which rightly so Justice Stephen Mubiru also discusses in that case. So the types of consideration include the following. 1, executed consideration. So executed consideration, this is consideration given where a promise is made in return for the performance of an act. Okay, that is executed consideration. The second type is executory consideration. This is given where there is an exchange of promises to do something in the future. Okay, so you promise each other and then you're promising to do something later on. Okay, then number C is what we call past consideration. Now this is what normally confuses students. Past consideration, this is where the act constituting the consideration is in respect of something in the past. Okay, we'll be looking at it later on. Okay, but in summary, past consideration, this is where you do something or you did something long ago. Okay, and then someone is paying you after some time, and the consideration you're giving for the contract is for an act that you did some time ago. Okay, that is what we call past consideration, because remember, consideration has to be two-way. For example, if I'm selling you your phone, if I'm selling you my phone, okay, let's say at 100,000, I'm selling you my phone, then you're giving me 100,000. Your 100,000, the money that you're giving me is the consideration coming from you, and then from me, the consideration is the phone. Okay, please note that. We shall be looking later at the rules governing consideration, that consideration has to be two-way, but we'll be looking at that later. But for now, what you have to know is that past consideration, this is where the act constituting the consideration is in respect of something in the past. Now, those are the types of considerations. Let's now proceed and we look at the general rule. Okay, what is the general rule governing consideration? Now, the general rule, you will look at section 20. Okay, look at section 20, subsection 1 of the Contracts Act 2010. It provides the general rule that an agreement made without consideration is void. So every time you make a contract, okay, or you have an agreement with someone and there is no consideration, just know that that contract is void as a general rule. Okay, however, there are exceptions. Now that takes us to the other element, exceptions to that general rule that a contract made without consideration is void. Okay, so we're going to look at the exceptions, and the exceptions are as follows. The first exception can be found under section 20 subsection 1A of the Contracts Act, and it provides that where the agreement is expressed in writing and registered under the Registration of Documents Act and is made on an act of natural love and affection between parties standing in near relations to each other. So that is exception number one. In summary, what that section is saying is that agreements that are made in writing and you register them, okay, there is an act called the Registration of Documents Act. The moment you make an agreement in writing and you register it under the Registration of Documents Act, under the laws of Uganda, and that document, or rather that agreement, has been made out of natural love and affection, okay, between two parties that are related to each other, that agreement, once registered, does not need to have consideration. Okay, that's the first exception. The second exception is under section 20 subsection 1B, where the agreement is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something that the promisor was legally compellable to do. So in summary, this section is providing for our second exception, which is that any promise to compensate a person who did an act legally that was meant to be done, okay, doesn't require compensation. I normally give an example of, for example, your parent or your father has already an obligation to pay for your school fees, okay? So assuming another person, okay, came and paid for you school fees, but your dad already has a duty to pay for you school fees, okay? So if another person came and paid for you school fees and your dad promised to pay them back that money, that agreement that your dad makes to pay that person back their money, okay, doesn't have to be supported by consideration for it to be enforceable, because from the onset, your father already had a duty to pay for you school fees. Are we together? So if someone comes and pays it, okay, your father cannot refuse to pay back that person's money, arguing that there is no consideration for his promise to pay that person who paid for you school fees. In summary, that is what section 20 subsection 1B is saying. Let's now proceed and look at section 20 subsection 1C. That also provides for another exception, which is a promise to pay a debt which a creditor is limited by the Limitation Act. Okay, now that is the third exception where consideration is not required. Now, under the limitation laws, if you have a debt, let's say if someone has your debt, they are what we call limitation periods. A time can reach when you can no longer sue someone to recover a debt, okay, or to recover your debt because you have taken a very long time. Now, if you have been stopped by limitation, the time within which you are supposed to sue has passed, you can no longer sue that person. You slept on your rights. It has been about 12 years. You know someone had your debt, but it's 12 years. The law stops you from bringing an action or a case, or bring a case in court. If that person who is already stopped by limitation makes a fresh promise to you, okay, to pay you, then he revives the previous debt. That's what we are saying, that a promise to pay a debt which a creditor is limited by the Limitation Act. He's already limited, okay, but he makes a fresh promise after the limitation that he will pay you that debt. Okay, that new promise that he makes to you to repay you the other debt which was stopped by limitation will become enforceable even without any consideration to be paid. So those are the three exceptions under the Contracts Act. Let's now proceed and we look at the basic rules governing consideration. Now there are basic rules that will govern consideration, and these are as follows. The first is that consideration must be legal with a lawful object. So consideration must always be legal and for a lawful object. Otherwise the contract is void. That's rule number one. Okay. Look under section 19 of the Contracts Act. It provides for that. Here what we mean is that the object of the consideration has to be lawful. For example, if you made a contract with a prostitute, okay, the object, okay, you having unlawful sex with a prostitute, the object is unlawful. Therefore, the contract to have sex with that prostitute cannot be lawful. Why? Because the object itself of the contract is unlawful. So the consideration that you give, the money that you pay the prostitute, okay, cannot be legal, okay? It is illegal consideration, okay? Why? Because the object itself is also illegal. So that is rule number one. Consideration must be legal, and it also has to be for a lawful object. The second principle, or the second rule governing consideration, is that consideration must be sufficient but not adequate. I repeat, consideration must be sufficient but not necessarily adequate. Now, these terms normally confuse students. I don't know why. Let us make it simple. What this basic rule means is that consideration should not be enough. Okay? Okay, it should not be. It is not important that consideration is enough, but it should only be. Rather, what this rule means is that consideration must be enough, okay, but it shouldn't be satisfactory. Please note, okay, the rule states consideration must be sufficient but not necessarily adequate. That's the rule. Where do you find it? Look at section 20 subsection 3 of the Contracts Act 2010. What does this rule mean? What this rule means is that consideration only has to be consideration, as I said earlier, must be sufficient but not necessarily adequate. What this rule means is that consideration must be enough, but it shouldn't be satisfactory. So the import of this rule is that consideration doesn't have to be equal to the value of what you're buying, but provided there is something, it is good enough. So for example, if you buy your iPhone at 2 million shillings, okay, and then maybe you are broke, you go to sell it, and then you sell it at about 150,000. You cannot later on argue that the money that was given to you was very small, and as such there was no contract. No, okay, consideration doesn't have to be enough. Okay, it just has to be satisfactory, and 150 or 180 that you'd have sold your phone would have been satisfactory. Okay, let's proceed and we look at another basic rule, which is that consideration must move from the promisee. Very, very important rule of consideration. Consideration must move from the promisee. Okay, so here you look at the case of Tweedle versus Atkinson. It's a case of 1861 volume. You look at, I think it's the citation is 121 ER, page 762. Now here the facts were that fathers of a young couple who intended to marry agreed in writing that each would settle a sum of money on the couple. Now one died before handing over the money, and the bridegroom eventually sued. Court held that Tweedle gave no consideration, so he failed. So here the rule basically is saying that consideration must move from the promisee. That's what I told you earlier, that consideration is two-way. Okay, when someone makes a promise to you, they have to give you something of value, and you also have to give them back something of value. The moment you don't give someone back something of value, then consideration would not have moved from one side. So meaning that for there to be a valid contract, consideration has to move from both the person who is selling and the person to whom something is being sold. Very important. Consideration must move from the promisee. Next rule is that consideration must be valuable, or what we call money or money's worth. So the thing that is being given as consideration must have some value. Okay, and consideration means something which is of value in the eyes of the law. You will look for furtherance of that rule. You look at the case of Thomas versus Thomas, a case of 1842, volume 2, Queen's Bench, page 851. Next, rule number 5 is that consideration must not be passed. Okay, it must not be passed as a general rule. Look at the case of Mark Addo. It's a case of 1951 Chancery, page 669. Now, in this case, what happened? Very interesting facts. A son and his wife lived in his mother's house. The son's wife paid for substantial repairs of the property, and the mother then made her 4 children sign a contract to reimburse her. Okay, that was the daughter-in-law, out of her estate that they would inherit. Now, after her death, they refused to reimburse her, to reimburse the daughter-in-law. And of course, she sued them, and eventually court held that her consideration was passed as it was before the agreement. So the general rule is that consideration must not be in the past. The moment it's in the past, then there cannot be a valid contract. Okay, very important rule to note. Let's, however, look at the exceptions. We are now proceeding to look at the exceptions to the rule that consideration must not be passed. So whereas, indeed, like I've stated above, that consideration, the general rule is that consideration must not be in the past, but there are some exceptions to that principle, and this is what we are going to quickly run through. The first exception is the rule in Lampley versus Braithwaite. This is a case of 1615, volume 80 ER, page 255. Now, in this case, Braithwaite was accused of killing a man and asked Lampley to get him a king's pardon. Lampley achieved it at considerable expense to himself and was promised a payment of £100, which he wasn't paid. There was a dispute. They went to court, and court held that although the consideration that Braithwaite that Lampley did was in the past, the consideration the contract was binding. So court in summary stated that although the consideration was past, the consideration was binding on Braithwaite. Okay. You will also look at the case of Pao On versus Lau Ying Long. It's a case of 1980. SC, page 614. That case lays down the conditions to consider past consideration. So court in that case laid down three considerations, that if you're going to consider past consideration as valid, you have to ensure that the 3 aspects are present. Which ones are those? The first one is that the act must be done at the request of the promisor. Okay, so the act which is alleged to be in the past must have been done at the request of the promisor. Secondly, it must have been understood that payment would be paid. That's the second ingredient or the second requirement for you to consider past consideration. Then lastly, which is element number 3, is that if any promise of payment had been made, it must have been legally recoverable. Very important element. So for you to consider consideration that is in the past, you have to make sure that those 3 ingredients in Pao On versus Lau Ying Long have been satisfied. Now, in conclusion on the aspect of past consideration, in light to the above rule, where one of the parties has requested a service, okay, and this is the rationale of past consideration in terms of the exceptions, it is that where one of the parties has requested a service, okay, the law sensibly concludes, okay, that he is prepared to pay for it, even though that service is then carried out without any mention as to payment. Okay, a promise to pay coming after the service is performed, okay, will be enforced by the courts, as we have seen in those 2 cases of Lampley versus Braithwaite and also Pao On versus Lau Ying Long, which lays down the ingredients, but wherein also court was in support of enforcing past consideration. So basically that's it. Now, let's proceed and we'll look at the consideration and the performance of existing duties. Okay, consideration and the performance of existing duties. And you have to be very attentive here, because this is where the question that I introduced you to from the very beginning is surrounding. Okay, it falls within this area or this subtopic. So we are going to look now at the consideration and the performance of existing duties. Okay, how does consideration relate to the performance of duties that certain people may have? Okay, can we take it that if someone does something that they already anyway required to do, that is enough consideration, okay, for there to be a binding contract? So these are some of the elements or aspects we're going to look at. So let's proceed. Now, the general rule, okay, please note, the general rule is that where a person does something by which he is already legally bound, this will not amount to sufficient consideration. Okay, either it doesn't matter whether they are bound to it by duty or by contract. Very, very important that if someone is already meant to do something, either as a requirement under the contract or because it's their duty, either by their office or by their responsibility or by their position, okay, if they already meant to do it, okay, then this will not amount, their actions will not amount to sufficient consideration, okay, for them to have a valid contract. Okay, I'm going to give you two cases that will illustrate this general rule. I'll give you the first case to illustrate duty, and then the second case to illustrate contract. And the second case is actually what your the question we looked at the beginning is actually about. Now let's look at the case of Collins versus Godfrey. Okay, Collins versus Godfrey. It's a case of 1831, 109 ER, page 1040. This case is about the duty. It illustrates the aspect of duty. Now, in this case, a police officer was under a court order to attend and give evidence at trial. Okay, his attendance was important, and Godfrey promised to pay him to ensure that he actually did come to court to give evidence. Court held that there was no consideration for it. Now, in this case, a police officer, remember, police officers have a duty to always go to court and testify, especially in criminal matters. Okay, they have a duty. They are not doing you a favor. They have to come and testify. It's their duty. Now, this gentleman actually went even ahead to promise to pay the police officer to ensure that he came to testify in his matter in court. Okay, and indeed, the police officer came to testify, and then the gentleman who had promised did not pay the money, and they had a dispute. They ended up in court. The police officer sued for the money that the other gentleman had promised him, and then court held that no, there was no consideration for it, meaning that the police office, there was no binding contract between the police officer and the other party that promised. Why? Because the police officer, the reasoning of court was that the police officer already had a duty, okay, to go to court and give evidence, and as such, this gentleman did not have to even pay him. It was not required. But also, court interestingly argued that the promise that this young man made to pay the police officer, okay, the police officer, because remember I told you, that's why I started from the rules governing consideration. Remember I told you that consideration has to be two-way. It has to come from both parties. So meaning that this person promised to pay the police officer, but the police officer did not pay any consideration in return for there to be a binding contract. So therefore, court said that what would have been the consideration, which is the police officer coming to court to give evidence, was not consideration, because the police officer already had a duty under the law. Okay, that case illustrates duty. Let me give you another case, which is part of the question which we looked at. This case illustrates contract. Okay, that is the case of Stilk versus Mayrick. It's a case of 1809, 170 ER, page 1169. Now the facts, 168. Now the facts of this case are that 2 of 11 members deserted the ship. There was a ship which was already on the waters, okay? Now, when they deserted the ship, the captain promised to pay the remaining more, Okay, there were some, deserted. There were others that stayed, and the captain said, I will pay you if you safely reach the ship home. Okay, and indeed they stayed on the ship. They maneuvered it, did their best, and they reached the ship very well where it was supposed to reach. Now they did, but unfortunately after doing so, the captain refused to pay them the money that he had promised them, which was more. He failed to pay them more. Court held that there was no consideration for the captain's promise. Okay, that was the holding of court. Why? Because they already had a duty under the contract, because remember, they had contracted with the captain to help him sail the ship to where it was supposed to go. So when 2 out of the 11 members deserted, then the captain made a promise to them that he will add them more money if they stayed and took the ship. So court held that actually there was no sufficient consideration. Okay, there was no consideration for the captain's new promise to pay them more, and as such there was no binding contract. Let's now proceed to look at exceptions. Now that general rule I've just discussed for you has exceptions. Okay, it has exceptions, and this is what we are going to look at. Okay, exceptions to that rule. And here you have to listen very well, because that's where the second case of William versus Rafi brothers and Nicholas contractors comes in. Now, the exceptions to that rule, meaning that there are circumstances where even when you have a duty, okay, or you even where you so meaning the exceptions here, we're going to look at the circumstances where even when you are already legally bound, okay, to do something, if you do it, your actions are enough consideration, okay, whether by duty or contract. So this is what we are going to look at, the exceptions to the other first rule that we just talked about. Exception number 1 is giving more than what is expected. Okay, let me explain that a bit more. Where what is given is more than could have been expected from the performance of the existing duty, then the excess is sufficient consideration for the new agreement. Okay, let's look at the case of Hartley versus Ponsonbe. Okay, it's a case of 1857, volume 7, E and B, page 872. It will illustrate this. The facts are a bit similar to Merrick, but slightly different. Now, in this case, 17 out of 36 members deserted the ship, leaving only 19. The remaining were promised to be paid more if they reached the ship safely. It was enforced because court enforced that new agreement. Why? Because the huge reduction of numbers made the voyage or the movement of the ship more dangerous. Okay, the agreement to continue in such circumstances was good consideration. So court held that because these people did more, okay, than was expected out of by them out of the contract, as such the contract was enforceable. Okay, please note that's exception number 1. Exception number 2 is and here you have to be very, 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 very attentive. So the second exception is where your question comes from. So exception number 2 is the exception in William versus Rafi. Okay, the exception in William versus Rafi. Now, where the party, okay, making the promise to pay extra is said to receive an extra benefit from the other party's agreement to complete what he was already bound to do under the existing agreement. The second exception is what I've just explained. That is the exception. It is called the exception in William versus Rafi. That's how they call it. And for you to understand it, I'm explaining it by saying that where the party making the promise to pay extra is said to receive an extra benefit from the other party's agreement to complete what he was already bound to do under the existing agreement, then that will be sufficient consideration. Okay, it will be sufficient consideration. I'm going to give you the facts of Williams versus Rafi Brothers and Nicholas, okay? Contractors Limited. The citation of that case is 1990. Volume 1, All England Law Reports, page 512. So in this case, in Williams versus Rafi, what happened is that Rafi Brothers Builders, which was a company, basically subcontracted the carpentry on a number of flats. They were building to Williams for £20,000, which he underquoted, okay, and wasn't enough. Now, due to a delay clause in Rafi's contract, which was punishable, Rafi then promised to pay Williams another £10,300 if he completed the carpentry on time. And indeed, he did complete it on time. And Rafi failed to pay the extra money that he promised. Okay. Of course, they ended up in court, and court established the above rule. And of course, Williams' claim succeeded. So, however, court went on to note that there shouldn't be attempts to extract the extra money by threats or coercion. The moment there are those attempts to extract money by threats or coercion, then the new contract will not be enforceable, of course, due to threats and coercion. So basically, that is those are the brief facts and the holding in Williams versus Rafi. I invite you to go and read that case in material detail, but also maybe to add you a bonus in that case, the test for understanding whether a contract could legitimately be varied was set out as follows. So court said that for any case to come under this exception, okay, we have to look at around 5 aspects, very, very important aspects. Now, one, if we can call him Peter, okay? If Peter has a contract to employ, let's say, someone called Belinda, okay, for work. So we'll first look, is there a contract between Peter, okay, to employ Belinda for work? We'll also look at the second test, which is, before it is done, A has reason to doubt whether B will or be able to complete his side of the bargain. That before the work or the contract is done, okay, does A have a reason to doubt whether B, or rather B, will be able to complete his side of the bargain? Then the second test, okay, is, did A promise B to pay more? As the third test. Then test number 4, A obtains in practice a benefit or obviates a disbenefit from giving the promise. Then lastly, there is no economic duress or fraud. Now, what court in summary was trying to say here is that for a case to come under this exception, which is the rule in William versus Rafi, 1, there must have been a contract to employ that other person. That's 1. 2, there must have been reasonable or reason rather to doubt whether that person you have employed, okay, will be able to complete his side of the bargain. Then 3, there must be a promise that this person that has employed the other has made to pay the other person more. Then number 3, this person who is making the new promise, okay, must obtain a benefit, okay, or a disbenefit from giving that promise. And then lastly, there must have not been an economic duress or fraud. That if these aspects are there, then the case will move under the exception, okay? The case will qualify under the exception in William versus Rafi. Now, in summary, why court really came out to say that the principle in William versus Rafi was an exception? This is because, you see, this person had been given a contract, okay? He hired another person under a sub-contract to do the carpentry, okay? This person he hired actually underquoted his price for the whole work, okay? And therefore, because he had underquoted, he could not be able to finish the work. Now, there was already a clause that was added in the contract of the person who had got the contract, okay, who is the contractor, which penalized him in case he didn't finish the works on time. Now, because the main contractor realized that the person he had contracted will not finish the work in time, he therefore went to him and told him that, look, if you finish the work before the target, I will pay you more money, okay? So there was a new promise that he made. So yes, the other person already, he promised, had a duty to finish the work, but then you see he made a new promise. But as if this is not enough, he was benefiting from the new promise that he made, because remember, if he had finished the work on time, he would have avoided the penalty. So there was already a benefit that he was getting if the subcontractor finished the work on time, okay? And indeed, the other gentleman put in effort and he finished the work on time. Now, this gentleman, Rafi Brothers, comes in and says, no, I'm not going to pay you the extra that I promised you to do if you completed the work on time. Why? Because anyway, we had already had a contract from the beginning which required you to do this work anyway. So he was changing goalposts. They ended up in court, and court agreed with William, said, no, look, you had a duty, okay, to pay this money, and indeed you should pay it. Now, this is where the disagreement or the issue, the legal issues are arising. Now, when you look at the question, so we are done basically looking at the whole topic of consideration. Those are the laws and those are the principles, okay? Now, having understood that topic well after my discussion, now someone is posing a question to you and they are saying that the question is as follows. Open quotations, that the decision of the Court of Appeal of England and Wales in William versus Rafi Brothers and Nichols Contractors Limited significantly eroded the rule in Stilk versus Merrick. Okay. Further, the reasoning employed by the court devalued the requirement of consideration, close quotations. Your duty here is, one, to discuss the veracity of that statement. Secondly, they are asking you if you agree anyway with the decision in William versus Rafi. And then lastly, you're required to give your answers. Now, the following is the proposed approach. When you're looking at this question, okay, this is the proposed approach that I would recommend that you look at, okay? In my view, this is and this is how you should approach the question. Number one, if you're answering this question, please start by defining a contract, okay? Why is it important to define a contract? Your examiner wants to know that, do you even understand a contract? Because remember, consideration arises from a contract. For there to be a valid contract, there has to be offer, acceptance, and consideration. So there is absolutely no way you're going to jump to consideration before first defining what a contract is. So step number one, in your introduction, ensure you're defining what a contract is. I already gave you the laws in my previous classes which define a contract. But to refresh your memory, Section 10 of the Contracts Act 2010 defines what a contract is. So in your approach, step number one, define a contract as per Section 10. After that, in your introduction, talk about the essentials of a valid contract. For there to be a valid contract, what must be in place? I already took you through these essentials of a valid contract. I need not repeat them, but I'll run through them. That is offer and acceptance, lawful consideration and objects, free consent, intention to create legal relations, and contractual capacity. Please note that do not go in the details to explain these essential elements, but hit on them in your introduction, because the question is not about essential elements, but you're laying a foundation and an introduction for your question. So talk about them. Number three, step number three in your approach, define consideration. Now we are starting to enter the gist of the question, okay? Define consideration. Already in this same class, I have already given you the definition of consideration, which is under Section 2 of the Contracts Act. I gave you the definition of Professor Traitel already, which I already illustrated for you. So look at that at those definitions, okay? But please, I encourage you, don't over-define words. Don't say according to section 2 defines consideration. In the case of this one, in the case you give like 7 cases defining the same thing. No. That is amateurish. Okay, it is amateurish, it is substandard, it's a substandard way of doing work. So just choose 1 or 2 definitions at the very most, and then you finish, okay? Don't multiple define things and again. So you can choose to use section 2 or use a case, that's sufficient. Don't use a case, use this and that, no. After defining consideration, now fall back and talk about, again in your introduction, talk about the types of consideration, okay? How many types are there? Of which I already discussed them for you. But also of interest. Please, you can't forget anything else, but you have to talk about the case of Laniero versus Okene and another. This is Civil Appeal number 29 of 2018. This is a very interesting judgment of Justice Stephen Mubiru. He lays down the principles of past consideration. Make sure you read that case. It's a locus class case in our Ugandan jurisprudence. Justice Stephen Mubiru makes an interesting discussion on the principles, so ensure you read it in totality and specifically read on the aspects of past consideration. Then after talking about those types, the various types of consideration, which I already discussed for you in this audio, then go to step number 5, which is the general rule of consideration. Give us the general rule. It's very, very important, of which I already discussed it for you. It's under section 20, subsection 1 of the Contracts Act 2010. Discuss it as well. Then also talk about the exceptions to that general rule, which I also discussed for you in material detail, and they are under section 20, subsection 1A to section 20, subsection 1C. Also discuss about those exceptions in summary. Don't be too wordy, okay? Don't be wordy, just hit the point directly, okay? Then after discussing those exceptions to the general rule, proceed then and talk about the rules governing consideration and the performance of existing duties, which I already discussed for you in material detail in this class. So talk about those rules, and after that, you state the general rule. What is the general rule? The general rule, I already gave it to you, which was laid down, which was espoused in 2 cases. That is Collins versus Godfrey for duty, and then Stilk versus Mayrick for contract, which case is also actually in your question. So discuss the general rule, and after you state the exceptions, and there are 2 exceptions which I've also discussed for you already. The first exception is where what is given is more than could have been expected from performance of the existing duty. I gave you the case of Hartley versus Ponsobe, a case of 1857, 7E and B, page 875. Then the second exception, which is the exception in William versus Rafi, which forms the substance of the question, also discuss that exception. And now here you're entering the body of your question. You're now in the body, okay? After discussing those 2 exceptions which I've just stated for you, then proceed, and here is where you should put most of your emphasis, okay? This is now, while answering this question, you should discuss the legal considerations. Very important. This is where the meat and the most of the marks are. Discuss the legal considerations in William versus Rafi Brothers and Nichols Contractors Limited, which citation I already gave you, 1990, volume 1, All England Law Reports, page 512. Discuss the legal considerations in Williams versus Rafi, okay? In contrast, please listen, in contrast, okay, with the case of Stilk versus Mayrick, 1809, 170 ER, page 1168. Discuss those 2 cases concurrently. Don't discuss the facts. We already know the facts, okay? We are interested in the legal principles as pertains consideration. Showing us or showing the examiners, you're discussing the legal principles in those cases. You should be showing the examiner whether in your view, this question is asking for your view, whether in your view Williams devaluated the requirement of consideration. Did it devaluate the requirement of consideration? And as you're discussing that, you give reasons for whatever conclusion you make. Okay, in your view, did that case devaluate did it devaluate the requirement of consideration? Okay, devaluate, did it take away that aspect? In your view, what do you think? And then after the last step of your approach, you conclude. Okay, you conclude. Now, in law school, how do we conclude? Please don't conclude in an amateur way. Students, you're fond of concluding in a very amateur way. Okay, very amateur way. You just say in conclusion, therefore, I have concluded. Now, what type of conclusion is that? Make sure you conclude. Your conclusion should have the following. 1, your conclusion should not be long. We don't want a very long conclusion. No, keep it medium. But your conclusion should be analytical. There should be some analysis in your conclusion. Your conclusion should give us your view and a summary of what you just discussed. Meaning that someone should be able to read 3 to 4 lines or 5 lines of your conclusion, and they already know what you have discussed in over 3 to 4 pages, okay, of content. So a conclusion should have a sober analysis of the legal principles as discussed above, and it should have your opinion and your conclusion as to the analysis. Okay, that is how a conclusion should be. So it should be sober, it should be a mature, an articulate and clear conclusion. Okay, very, very, very important. So basically that is the approach to the question. But as a bonus, I'm going to give you what my view is. Okay, what my view is. Like I told you, this question requires you to have a personal view, and you can take any view, meaning that you can decide to make an argument and say William versus Rafi brothers significantly eroded the rule in Stilk versus Merrick. You compare the two cases and the legal principles, and you give us reasons why you think so. But you can also make a reverse argument. Okay, because this is university. At university level, we don't have standard answers, especially for such essay questions. We just want you, we are interested in you making an analysis, okay, of the principles. And you have to make sure that your analysis is correct, because an analysis must be based on law, okay, or clearly established principles. Okay, so please don't argue facts. No, argue the principles in those cases. And that is what will give you a distinction in your work or in your essay question. So, what is my view? Me personally, I think that I would take the reverse position of the question, and my view will be that Williams versus Rafi did not actually significantly erode the rule in Stilk versus Merrick. Why would I say so? My reasons are straightforward and simple. When you look at Merrick, as we earlier on discussed, when you look at Stilk versus Merrick, the legal principles therein espoused are distinguishable from the principles in Williams versus Rafi. First of all, in Williams versus Rafi, there was a benefit that Rafi brothers was getting from making a new promise. Okay, whereas that was not the case in Stilk versus Merrick. Here in Rafi brothers versus Nicholas, the benefit they were getting is trying to avoid a punishment or a sanction for if they had not finished their contract on time. Okay, so they made a new offer to Williams, where actually anyway he could not have hit his target because he had underquoted the previous amount that he bargained. This is not the case in Stilk versus Merrick. In Stilk versus Merrick, here this captain was not getting any benefit. He was simply fulfilling his duty of ensuring that he reaches the ship safely to its venue. So that's the first distinguishing feature. But also the second distinguishing feature is that when you look at Williams versus Rafi, in Williams versus Rafi, there were no elements of coercion or threats. Okay, there were no elements of coercion or threat. It is actually Rafi who approached Williams and made a new offer, and in my view, it would have amounted to sufficient consideration. Then thirdly, why I think, in my view, that Williams versus Rafi did not actually devaluate the requirement of consideration is that when you look at the judgment of Russell LJ in that case, he actually hints on the same, okay, and states that Williams versus Rafi does not intend to take away the rules in Stilk versus Merrick. It is simply refining those rules, okay, and bringing in another exception. So even in the judgment of court, the judges themselves actually make it clear. But then also of interest is that, which now forms the fourth to fifth legal distinction between the two. In Williams versus Rafi, court actually gives the test, okay, under which someone can proceed under the exception in William versus Rafi. So there is a test, okay? There is a test, and the test, I already shared it with you, that there has to be a contract of employment. There has to be reason to think that a person you've hired will not be able to do their part of the bargain. There must have been a promise to pay more. And then the person making the promise must be either acquiring a benefit or a disbenefit, and then there must not be economic of duress or fraud. So there is a test that you have to satisfy. Not every person can come under the exception in Williams versus Rafi as opposed to Stilk versus Merrick. So in my view, I think that these two are fairly distinguishable. The cases are distinguishable, and there was no devaluation of the aspect of consideration. Consideration still stays a fundamental requirement of the contract, okay? And it was nowhere disoriented, and the principles governing the same are still standing straight, and they are on all fours. So that is my analysis. You can choose to take the other position, provided that you can back it up by principles of law. But in my view, there was no any sort of devaluation. And then also lastly, we do not know, or we are not aware of any case that has come out to outrule the decision in William versus Rafi and Nichols. And as such, that decision still stands as law, and therefore I do not have any reason to disagree, especially where I feel that the decision of the judges in that case was a good one. So basically that is it on the approach. Thank you very much for listening in. I wish you the best. Once again, my name is Mutiaba Conrad. Please do not forget to like and subscribe to my channel. Every time you subscribe, you'll be able to get always these updates and guidance so that you're able to perform well in your legal field or in your law school. And in case you want me to guide you on anything, please make sure that you always comment on my channel and also make comments on some of these classes that I give you. Thank you very much. May the Lord God bless you. Bye-bye. See you next time.